If your case is dismissed by the immigration court, but you want to keep pursuing your asylum claim, you can do that by filing the application with USCIS, the agency that handles what are called affirmative asylum cases. And in this video, I'm going to tell you who might benefit from this and how to actually do it. Stick with me to the end because I'm going to tell you about something you need to consider carefully before doing this, and it's something that I'm pretty sure you're not already aware of. I'm Brian Manning, and I used to be an asylum officer with the government, but now, as an asylum lawyer, well, I help immigrants all over the country secure their future in America through asylum. The Biden administration announced a sweeping change to its policies regarding who it will attempt to deport from the United States. The government decided that not everyone who is in deportation proceedings is actually a priority to be removed. You see, with over 1.6 million cases pending in immigration court, the government just doesn't have the resources to move these people through the process. Neither the immigration courts nor the agency charged with trying to get people deported, which is called ICE, has the manpower to handle this backlog efficiently. So the government decided to prioritize cases for deportation. The idea was to focus on people who have a criminal record or whom the government thinks may be dangerous or who have something else in their history that makes their presence in the United States undesirable. This policy shift recognized that there are lots of people in deportation proceedings that, frankly, the government doesn't really care about deporting. Yes, they technically are eligible for deportation, but they're not a priority. So the government created standards to evaluate cases and, based on several factors, started to seek to dismiss from immigration court the non-priority cases. And they did this, in many cases, unilaterally. Now by that, I mean that the lawyers for ICE in some cases didn't even ask whether the person in removal proceedings wanted to have their case dismissed. ICE just made the request, and often the judge agreed with it, sometimes even over the objection of the asylum applicant. Now, why would a person not want to have their case dismissed? After all, being in deportation proceedings isn't normally considered a good thing. You're at risk of receiving an order of deportation and could actually end up being removed. Well, you see, there are a couple downsides for asylum seekers whose cases in immigration court are dropped. When your case in court goes away, your asylum application goes away with it. You no longer have an asylum claim pending. It's like it just disappears. And there are two main problems with this. But before I tell you about those two problems, if you want to maximize your chances for asylum success, then be sure to hit the subscribe button and bell notification so that you don't miss the insights that I share on this channel. Okay, so what's the downside of your case being dismissed? Well, one, you can't get asylum, or at least not based on the application you had pending before the judge. And two, your work permit based on a pending asylum claim will cease to be valid, so you can't continue working legally. And these are big problems for many people. Lots of people want to have their asylum claim heard. They think that they've got a chance for success, and they might not have an alternate route to get long-term status, so they really want to pursue their asylum case. And of course, the inability to work legally can be very problematic. So what can you do if you were seeking asylum, but your case in immigration court was dismissed? Well, you can apply for asylum with USCIS. And this is true whether you originally applied with the immigration court or you applied with USCIS and then had an interview at the asylum office and had your case referred to an immigration court. In both scenarios, you can apply with USCIS upon dismissal of your case in immigration court. Now, I've got to say, if you originally applied with USCIS and had an interview but were referred to court because the asylum officer decided that you did not qualify for asylum, then it's going to be really hard to win if you decide to apply again. Many officers will have a hard time going against what one of their colleagues already decided about your case. There's an inclination to essentially uphold the prior negative decision. But it's not impossible to win under this circumstance. You may get a more sympathetic officer this time, or conditions in your country or the policies for interpreting the law may have changed in a way that's favorable to you. But listen, you need to understand that there is some risk in applying for asylum with USCIS. If the asylum officer makes a negative decision and you don't have lawful immigration status when that decision is made, then you'll be placed in deportation proceedings again. There, you would be able to keep pursuing your asylum claim. You might be able to get your immigration court dismissed again if you wanted to do that, but there's no guarantee of this. By the time you end up in immigration court again, the government's policies may have changed such that it's not so easy to get a case dropped. Now, let me note that the risks of applying with the asylum office are lower if you've got temporary protected status, known as TPS for its initials. That counts as lawful status, meaning if you get a negative decision from the asylum office while your TPS is valid, then you will not be sent back to immigration court. Instead, the asylum office will just deny your claim, but nothing else happens. You just continue with your TPS status. This is good news for many of my Venezuelan followers out there who have recently gotten TPS or are probably going to get their approval soon. Okay, now that you know that applying for asylum with USCIS is an option after your immigration court case is dismissed, well, let's talk about practicalities. How do you do this? Well, the first thing to consider is which form to send in. Sure, you have to send in the asylum application form called Form I-589, but which one do you use? Do you just take a copy of the one that you previously submitted and mail it now to USCIS? Or do you treat it like a wholly new application using the current version of the form? It's the latter. You need to fill out a new application form and you need to be sure to use the current version of the form. Now to get the current version, I'm going to Google USCIS Form I-589 and click on the top result, which takes me to the USCIS page for asylum applications. Then I'm going to scroll down and under Forms and Documents Downloads, click on the link that says Form I-589. Now, the PDF that opens up will be the current version of the form. Note that at the time I'm making this video, you cannot apply for asylum online with USCIS if you were previously in deportation proceedings in immigration court. If your case was dismissed by an immigration judge, then you have to mail your asylum application to USCIS on paper. But here's the thing. You do not mail it to the same place that you would mail your application had you never been in immigration court. You see, most people applying for asylum with USCIS on paper send their applications to one of 3 offices that are called service centers. But there are certain circumstances under which USCIS has said that you should not send your application to the service center with jurisdiction over your residence, but rather should send it to an office called the Asylum Vetting Center. And people who have previously been in immigration court fall under this category. We see this on the USCIS page for asylum applicants. If we scroll down to the Special Instructions section and click on it to expand it, we see a list of circumstances under which an applicant should file with the Asylum Vetting Center. And one of those says previously in immigration court proceedings. So you would need to file with the Atlanta Vetting Center, the address for which is shown right here in the Special Instructions section. All right. Last thing, and this is extremely important, so I'm glad you're still with me. You've got to file quickly with USCIS upon your case being dismissed in immigration court, or else you'll likely be denied. Why is that? Because of the 1-year filing deadline. You may know about this rule. It says that to get asylum, you need to file your application during your first year in the United States. But what does this mean for people who are now applying for asylum with USCIS after having previously applied? In deciding your new case at USCIS, will they use your new application date for purposes of the 1-year filing deadline analysis, or will they use the date that you filed your previous application? Now, this is important because most people who will be applying with USCIS upon dismissal of their case in immigration court entered the United States over 1 year ago, such that their new application with USCIS will not have been filed within 1 year of their arrival in the country. Now, are they out of luck? Thankfully, we do have a sense of how USCIS is going to treat this issue thanks to publicly available guidance for asylum officers. It says that, for purposes of the 1-year filing deadline, in cases where a person's asylum case was terminated by an immigration judge, the officer will look to see how long it took for the person to file with USCIS after the case was dismissed in court. They have to decide whether the application was filed within a reasonable period of time with USCIS after the dismissal. Now, the guidance does not define concretely what constitutes a reasonable amount of time. There's no bright line rule for this. But the guidance does suggest, in citing to a court case on the topic of the 1-year filing deadline, that 2 months will normally be considered reasonable. Now, to be safe, I recommend filing with USCIS within 1 month of dismissal in court. Anything beyond 2 months starts to become questionable. If you wait 3 months or more, there's a good chance, I believe, that your case will be denied because of the 1-year filing deadline. If you're ready to take the next step and get individualized help with your asylum case, then call my office today. It's 713-909-0401. And remember, we help people all over the country, so it doesn't matter where you are. Call us now to schedule an asylum strategy session so that we can help you secure your future in America through asylum. Again, I'm Brian Manning, and it's an honor to serve you in your asylum journey.